Good afternoon, everyone. My name is Binh Rey. I'm a trademark attorney and I'm also the general manager at Applied Marks. If you're a business owner here, it's really important that you come and watch this presentation because I could save you a lot of money in terms of protecting your brand from the very start. Many people do not understand what trademarks are, and it's important that you do understand, or else later on you might get sued. And we don't want you to be sued, so come and join us. I'll be starting the presentation now. There are different types of intellectual property. I am an expert on trademarks, and it's the protection of the brand. When you register a trademark, you have 10 years of protection. If you have an invention, you may want to get a patent to protect your invention. If you have designs, you can also get a registered design mark. Copyright. Copyright is automatic in Australia, and you can, if someone's copying your website, you can actually go to the Council of Trademarks in Australia and complain. And then we've also got trade secrets. So KFC, Coca-Cola, their recipes are a secret. No one knows what is in the syrup of Coca-Cola, and the herbs and spices of KFC is top secret as well. So they've actually got no intellectual property protection under only trade secrets, because they don't want anyone to know what the secret ingredients are in their recipe. So first of all, why do you need a trademark? Well, it gives you the legal rights to use the brand name. A trademark allows the trademark owner to continuously use their brand in the marketplace without fear of trademark infringement. It's a valuable asset that's able to be sold, assigned, or licensed. So what is a trademark? Well, a trademark can be a word, logo, slogan that differentiates your products or services of others in the marketplace. There's types of trademarks. You can trademark letters, numbers. You can trademark words, McDonald's, McCafe. You can trademark slogans. Just do it is a famous Nike slogan. Aspects of packaging. McDonald's Happy Meals are trademarked. You can even trademark a scent. Not very popular, but you can do that. You can trademark a shape. The shape trademarks, the Toblerone chocolate, are famous. And you can trademark color marks as well. The Cadbury's color mark is famous. The sound mark. Netflix has trademarked the introduction music that they introduce at every episode. They've trademarked that as well as a sound mark. So which one is the better protection? A word mark or a logo mark? Well, the word mark, because the word mark gives you the exclusive rights to those words that you're protecting in the marketplace. Where in the example of the logo, the Coca-Cola logo, as you can see, their first logo was in 1886, and they've actually changed the logo over the years. And each time you change the logo, you actually have to get a new trademark. So it's actually quite expensive as well to maintain a logo trademark unless you don't change it. So the word mark always trumps the logo mark. So there are 45 classes of protection for trademarks. Class 1 to 34 are product classes, and class 35 to 45 are service classes. Depending on what type of business you are, you might have multiple classes, or you may only need one class. And each trademark has one class. For example, if a ladies' fashion brand sells clothing and handbags, they will need two classes, one to protect the clothing and one to protect the handbags. So the number one misconception, and even today when people have actually come to the store, they say, my company name gives me protection for my business. And that is 100% completely false. A company name, a trading name, a domain name, and even trading history does not protect your brand from legally in the marketplace. Only a trademark does. And the misconception number two, well, surely ASIC will not give other people a similar name to my business, but this is false as well. As you can see, my client was Australian United Developments, and the other party was Australia United Development. As you can see, it's only two letters out. And you can't tell me that's not similar, and ASIC had given them similar company names. And they both operated in the property development industry. So as you can see, ASIC does give similar names to other traders. And for the non-believers, have a look at this. I've used ACE, and as you can see, they're all builders, and ASIC has given them companies in every state similar ACE names. ACE Construction, ACE Constructions with an S, ACE Construction Oz, ACE Construction. So you can't tell me that that brand name is not similar. ASIC do actually provide similar, or gives out company names that are similar. So I'll run through this quite quickly. So if you're starting up a business, a descriptive brand name is not good because other traders should be able to use that brand name. So if you have a descriptive brand, the trademark authorities will not give you a trademark. So it's very difficult to protect a descriptive brand. So these are examples of descriptive brands. My Local Plumbing Services, My Local Plumber, Elite Plumbers. As you can see, we all know they're plumbers, right? And you're just adding an extra word at the front of it, like good plumber, better plumber. You're not going to be able to trademark it. So these are in regards to descriptive brands, you can actually trademark the logo. But the logo only gives you protection for the look and feel, does not give you the exclusive rights to those descriptive words. Okay, so I love this part because it's case studies. All right, case study 1, Musashi versus Asahi. And it was Nestle versus sole trader James Christian. So when James started the business, Asahi, he didn't bother to get a trademark. He may not have known that he needed a trademark. But anyway, Nestle took him to court after 4 years of being in business, and the business was very successful. So anyway, they went to court, and these are the lessons learned. And of course, James actually lost the court case, okay? So James said to the judge, I didn't know when I started the business that I was infringing on Musashi. And the judge said, that's not an excuse. You can't claim ignorance. James said, I have a domain name. I have a trading name. But that does not, the judge said, that does not give you any legal rights to the brand name, Asahi. So what happens is that in the end, at the end of the court case, after hundreds of thousands of dollars spent, you are leaving it to one judge, one person to decide if something is similar or not. And unfortunately, in this case, this one judge decided that he thought Musashi and Asahi were too similar. So in the end, he ruled against Asahi. So what had happened was the judge said James should have applied for a trademark at the very start of his business. Because if he actually was lucky enough, he might have been granted the registration of that business so that he wouldn't be in this place. Because if he had a trademark, Nestle could not have sued him. But unfortunately, James didn't attempt to obtain a trademark, And if he did attempt it and the trademark registration people said, no, it's too similar, at the very beginning, he could have then gone back to the drawing board and brainstormed a new name for his business and not to have lost his business 4 years later through to a trademark infringement case. So what was the cost to James? Well, he had to shut down his business. It was a very successful business. He lost his initial investment of $200,000. He had to pay Nestlé's fees, legal fees, and he was stressed for over 2 years during this court case. So this is a really good case study because it just shows you how important it is to find out whether the brand name that you're starting out with is trademarkable at the start. If you've got a trademark, that means you can safely promote your brand in the marketplace. Case study 2, trademark trumps the company name. And this was one of our clients that rang us up and said, my accountant told me that I got the company name iHub Optical Proprietary Limited. Go ahead and open your optometry shops. So he did. They went and opened 2 optometry shops. And when they rang me, I actually said to them, actually, just tell me the brand name. Don't tell me who's suing you. And I was able to find out who was suing them because all I did was a Google search and a trademark search. And guess what? Who sued them? OPSM. Because OPSM, I found them on Google. They have OPSM iHub. And iHub is a sub-brand of OPSM. So therefore, companies can have sub-brands just because no one knows that iHub is a sub-brand of OPSM. They own the trademark for it, and therefore they have the legal rights to promote that brand, where my client didn't. They only had the company name. So the client had to rebrand at a cost of $26,000, only 2 months of operation, and the irony of the whole thing is that they are still trading as iHub Optical, but they couldn't promote iHub as the brand. So they actually ended up getting a trademark for Expectico, and they just got a trading name, Expectico. So this is why it's really important that you get a trademark, because these mistakes can be actually avoided from the start. And as I said to you, it took me a minute to find out who was suing them. And this is an infringement case that's happened to us. So at Applied Marks, we're currently spending a lot of money on SEO and things, and we have a really good reputation for service. And one day I was just checking Google on our Google ads, and then I found this ad there. It says Applied Marks, doesn't it? And you would expect when you click on it that it's Applied Marks, but actually it was one of our competitors. So one of our competitors had actually used our name to advertise for their services. So I've actually wiped out their name because, there's no point saying who they were, that were trying to pretend to be us. So basically what we did, we own 2 trademarks for Applied Marks. So what we did was we rang them, we sent them 3 screenshots of the ad over a period of time during the day, and we basically said, we own 2 trademarks. We are asking you now to never use Applied Marks on your Google ads. And I said, instead of sending you a cease and desist letter, if you can just take it off, we'll be monitoring you to make sure that you're not pretending to be us. Because why should another company pretend use your reputation to obtain business? Why don't they provide good service so they can get business? So that's why trademark protection is really important, to protect your reputation. Because what if someone actually went through and thought it was us and they had really bad service? Then our brand would be affected as well. So basically our competitor did take it down only because we had a trademark. If we didn't have a trademark, they wouldn't have taken it down. Okay. Oh yeah, this one's a really good one if you've got an e-commerce business. So we had a client who lost his Facebook page and also his Instagram page because of trademark infringement. He had 45,000 friends in his community, and he had 15,000 Instagram followers. And overnight, his business went poof because he couldn't reach his 45,000 followers or 15,000 followers in Instagram. So both his platforms were shut down overnight because of a trademark infringement. And basically, the client cannot reinstate his business, his Facebook pages and Instagram, unless the other party who owns the trademark asks Facebook to do so, and they're not going to do it. So now this client has to start from scratch. His business is actually halted, unfortunately, because he can't find, well, his clients can't find where they can buy it from him. He's actually also had to take down his Google website as well because of the trademark infringement. And he had been in business for 10 years. So as the examples I've given you, it could be 2 months, it could be 10 years. And you could get shut down due to trademark infringement. So these are my top 10 tips of trademarkable brands. So first of all, avoid descriptive names if you're looking to start up a brand. Avoid cursory words because they're not allowed. So see, some people have been trying to trademark that and that's been rejected. Avoid copying somebody else's brand. Surely you're creative enough to not copy somebody else's brand. And why would you? That brand was there first. You've got to spend more money to get on the first page of Google. And as you know, with SEO and everything, you've got to spend a lot of money to get on the first page of Google anyway. So why would you copy somebody else's brand? Avoid personal names. Oh my God, there's so many lawsuits. Kylie Minogue versus Kylie Jenner, Katy Perry versus Katy Perry. Unless you're a celebrity and you've got tons of money, avoid personal names because you don't have the money to go to court over it. Avoid geographical names because you won't be able to get trademarks for that too. Ensure that you get your domain names because it's a cheap way of making sure that your real estate, internet real estate, is covered. Invest in a good graphics designer. Don't do your logo in Canva. Don't do your logo on Fiverr because you never know where that copyright thing is from. So if you don't own that original artwork, you don't technically own that logo. And try to trademark your brand prior to launching. Not everyone can do it, but try to. Once you obtain trademark protection, you need to police it. There's no such thing as a trademark police force out there going, you're infringing, you're infringing. No, if you see someone infringing, you must act on it and tell them to stop because it's your right to that brand. So, and the other thing is, unlike domain names, you have to use it or you lose it. So you can't sit on a brand name. You've got to use it within 3 years or somebody else can revoke your trademark, which is great because it then stops people. Can you imagine if everyone can just trademark everything? There'll be nothing to be able to be trademarked. And that's why with domain names, it's very hard to get the domain name you want because there are so many cyber squatters out there for domain names. And that's it. But before I finish, I just want to introduce Noel Cowell. He actually has trademarked his brand, and we're really proud to know him because he actually bought a business that started in 1932, and he was the third owner. And he was the one who ended up trademarking the brand because he saw the value of it. And now if someone pretended to be Davy's Chocolates, Noel can take them down on social media, and he can also stop them from starting up a chocolate factory. So for everyone that's been here, I'll give, oh, come on! So if you value your brand and you can't afford to change the brand name, it's really important that you consider trademarking. Our slogan is protect your brand, protect your success. And actually, Michael Wolsey is a client of ours. We actually trademark Wexpo. Woo! We're the trademark attorney firm that helped Michael trademark it three or 4 years ago before he even started the business or started the brand like it is today. So thank you very much, Michael, for having us at Wexpo, and I hope that wish you all the success in many years to come. So thank you.